Hello, everyone, and welcome to Hopkins at Home. I am Stephen Schneebaum, Practitioner-in-Residence and Interim Director of the International Law and Organizations Program at the School of Advanced International Studies in Washington, D.C. It is a great pleasure to be able to speak with you this afternoon. The topic of my talk today is the death penalty in America. In the interest of full disclosure, I should state my background and standpoint on this issue at the outset. I have represented men on death row since the mid-1980s. Two of my clients have been executed, one in Texas in 1995 and one in Virginia in 2000. And my colleague Cynthia McCann and I are currently battling the state of Alabama to save the life of our client who has been on the row since 1997. I am a categorical death penalty opponent, but my goal here is not to advocate for a position on capital punishment as such. It is to explain how the death penalty is applied in the United States today. As a lawyer, I can make a case for judicial executions in the abstract, but the problem with the debates that all too frequently occupy the public space is that the law does not operate in the abstract. It affects real people and has real consequences, including in this instance, the difference between life and death. So the question must be seen as a very practical one, and I propose to frame it in those terms. Does the application of the death penalty in America today satisfy the standards that a democratic society requires for the laws and principles by which it is governed? What are those requirements? I suggest that we look at four principles that are fundamental elements of the rule of law in a democracy. We should, indeed we must, insist that every part of our legal system not just aspire to, but actually reflect these values. And this must be true not only on paper in our founding documents, but in practice. This exercise, testing whether high-sounding language of our Constitution translates into reality, has been a significant influence on our nation's history. Everyone remembers the words of Lincoln's address at Gettysburg, when he described the country over which he presided as conceived in liberty and dedicated to the proposition that all men are created equal. Yet that country was nevertheless in the midst of a horrific war to determine, as he put it, whether that nation or any nation so conceived and so dedicated can long endure. We still face that same challenge. The three propositions that I argue are integral to any regime, any legal regime worthy of that description are these. The law must first apply to all of its subjects equally, and in particular may take no inappropriate account of such immutable factors as race, sex, religion, national origin, age, or sexual orientation. Second, the law must be predictable, meaning that outcomes of legal processes, even if they should never be mechanical or soulless, may also not be arbitrary or inexplicable. Third, the law must be proportionate, by which I intend that the severity of the state's response to acts offending against its good order must be capable of adjustment depending on the nature of the act and the culpability of the offender. And finally, the law must be consistent with the principles and practices followed in the rest of the world, or when it differs, the divergences must be justifiable, paying what Thomas Jefferson called a decent respect to the opinions of mankind. Having stated the tests this way, it will be no surprise that the death penalty in America, as it is interpreted and applied today, flagrantly fails each and every one. The empirical evidence behind that claim, I argue, is clear. equality, predictability, proportionality, and consistency with the values of the community of nations. I propose to look at each of these in turn. But before we do that, let me present a few statistics to give our review of the facts some context and a little history so that the analysis that I am offering makes sense. First, some numbers. There are, as of this very moment, approximately 2,550 men and women on death row somewhere in America. With the imminently anticipated statutory change in Virginia, which is about to become the first former Confederate state to abandon the practice, 27 states, the federal government, and the military retain the death penalty. However, this number is a little misleading. 3 of those states, California, Oregon, and Pennsylvania, currently have governor-imposed moratoria. That is, all writs of execution have been suspended with various provisions for when or whether they may be revived. 730 of the total number of prisoners under death warrants are in one of those states. In addition, 14 other states have the penalty on the books, but have not conducted an execution in 5 or more years. Only 5 states executed someone in 2020: Alabama, Georgia, Missouri, Tennessee, and Texas. And of course, in its twilight months, the Trump administration ordered the execution of 13 federal prisoners over a period of 6 months, more than all of those killed by the United States in 7 decades between 1950 and 2019. There has been a significant drop in executions over the last 10 years. There were 295 judicial killings between 2011 and 2020, or an average of just under 30 per year, while between 1991 and 2010, the annual average was 55. In 1999, the high watermark, 98 people were put to death in this country, 35 of them, 1 every 10 days, in the state of Texas alone. More dramatic still has been the sharp decline in new death sentences pronounced. In each year during the 1990s, between 250 and 310 capital sentences were handed down across the country. In 2011, that number dropped for the first time to below 100. Since 2015, the number has been less than 50, and last year, only 18 new death sentences were issued, and 5 of those were in California, a moratorium state. Now for some history. Judicial executions were, of course, commonplace in the early days of our country. 32 executions were carried out mostly by hanging in the original 13 states in 1787, the very year that the Constitution was ratified. And while the Fifth Amendment specifically makes reference to capital crimes, the Eighth Amendment also forbids cruel and unusual punishments, and the Fifth and 14th require that all convictions and sentences be rendered in accordance with the due process of law. Both of those open-textured phrases have been the subjects of extensive legislative and judicial interpretation since the very first days of the Republic. In 1972, in the landmark case of Furman v. Georgia, the Supreme Court held by 5 votes to 4 that the death penalty as then administered was a violation of both constitutional guarantees. What made death sentences cruel and unusual and a denial of due process was the arbitrariness by which they were handed out. Juries simply had too much discretion in rendering their decisions, and prosecutors too much latitude in their arguments that a defendant deserved to die. The obvious potential for decisions to reflect racial prejudice, especially but not exclusively in the South, was constitutionally unacceptable. Between 1968, when Furman was first reviewed at the lower court level, Until 1976, not a single person was executed in the United States. However, states intent on restoring the practice took Furman not as a condemnation, but as a challenge. If arbitrariness was, so to speak, the fatal flaw in their sentencing schemes, it could be fixed by reducing or removing discretion and by adopting statutes that appeared, at least, to require a measure of control over the kinds of cases that were potentially capital and the kinds of defendants who would be eligible for the ultimate sentence. 4 years after Furman, the Supreme Court found that the state of Georgia had succeeded in satisfying the constitutional objections. In Gregg v. Georgia, the Supreme Court approved as not cruel and unusual and not violative of due process a formula that split capital trials in two. In the first phase, the jury is tasked with the usual assignment of determining unanimously and beyond a reasonable doubt that the defendant is guilty of the crime charged, which must be specifically defined by law to contemplate the possibility of a capital sentence. And after the conviction, the jury is required separately to address the penalty to be imposed. It must take into account aggravating factors presented by the state and mitigating ones offered by the defense. Aggravators may include the awfulness or brutality of the crime of which the defendant has now been convicted. Was there excessive violence or gratuitous abuse, such as making the victim beg for her life? Or other aggravators could be that the crime involved homicide of a child, or multiple murders, or the killing of a police officer, or a contract killing. States have great latitude in developing their own lists. The defendant, by the same token, must have the opportunity to offer mitigating evidence, urging a sentence less than death. It might be statutory, the age or mental capacity of the perpetrator, for instance, or it could simply be evidence to demonstrate that death would not be, in Justice Sandra Day O'Connor's words, in a decision released on the same day as Gregg, a reasoned moral response to the defendant's background, character, and crime. That is the law today in all jurisdictions that conduct capital trials. All of them provide for the bifurcation of proceedings into guilt and punishment stages. The jury, incidentally, has the power to recommend, but not to issue, a sentence. In every state but one, if the jury recommends against the death penalty, the judge may not impose it. And if the jury recommends death, the judge has discretion to dial the sentence back to life imprisonment. The one remaining state that permits what we call judicial override, that is, the decision by a judge to impose a death sentence against the wishes of the jury, is Alabama. I'll come back to that later. Although Gregg lifted the constitutional ban on capital punishment, the Supreme Court has not definitively slammed the door on the Eighth Amendment, that is the cruel and unusual punishment argument. To determine whether a punishment is cruel and unusual, the court has pronounced, courts must look beyond historical conceptions to what the court called the evolving standards of decency that mark the progress of a maturing society. Applying those elusive evolving standards, the court forbade the execution of individuals with intellectual disabilities in 2002, as well as those below the age of 18 at the time they committed the murders of which they were convicted in 2005. And in 2008, the court limited the application of the death penalty to homicide crimes. This, by the way, ended one especially nefarious use of capital punishment, which was to allow the execution of Black men for sexual violence against white women, while white men who committed identical crimes against Black women were virtually never condemned to die. Subject to those and a few other constraints, however, the states are still permitted a wide margin of appreciation in deciding precisely what categories of homicides might make a perpetrator eligible for the ultimate punishment. Over the last several years, the majority of death penalty impact litigation reaching the Supreme Court has focused on the methods of execution. Most states direct the use of lethal injection as the sole means of conducting judicially sanctioned killings. The protocols for carrying out executions have been challenged repeatedly on the grounds that lethal drug cocktails, as we euphemistically call them, subject prisoners to undue pain and suffering. The current court, however, with its decidedly conservative majority, has shown little patience for such cases. Interestingly, however, while the court has refused to intervene, pharmaceutical manufacturers have been less reluctant. Drug companies, in Europe in particular, have refused to supply products to be employed to end rather than to preserve human life. This has not, however, had the effect it was probably intended to have. Instead of deterring executions, it has impelled states intent on conducting them to investigate unproven or even archaic means. My client in Alabama, for instance, has recently been presented with the option of allowing the state to asphyxiate him with nitrogen gas just in case the necessary drugs are not available on the day that he is scheduled to die. I hope I've now laid sufficient groundwork to conduct a sensible examination of the 4 questions with which I began my talk. If you are not persuaded that I have done so, please let me know during the Q&A. So now let's look at those 4 factors. First, is the death penalty in America applied equally? Well, in a word, no, it is not. Not even close. Inequalities may be seen in 2 critical respects: race and geography. The latter is perhaps more obvious. The former is more insidious. Let's look at both. As I've told you, there are about 2,550 people on death row in America today, 2,500 men and 50 women. Of those 2,550, 1,062 are Black, 42% of the total, roughly 3 times the portion of the US population that is Black. All minorities, people who are Black, Hispanic, Asian, or American Indian, make up 38% of the population of our country, but 58% of the population of death row. The probability that such disparities are the result of chance are small, but we do not need to speculate. There are numerous facts to give us a clue as to what is really going on here. If we are looking for the really dramatic evidence of race as a significant factor, a significant influence on who gets the death penalty and who does not, we need to look not at the race of the perpetrators, but at the race of the victims. And what we see may be shocking. Of the 17 people executed in the United States last year, 5 were Black, bad enough. But of those 17, only 2 were convicted of murdering a Black victim. And this is not an anomaly. It is a well-documented pattern. As long ago as 1987, this very issue was presented to the Supreme Court. An exhaustive study of the death penalty in the state of Georgia at that time demonstrated that even after taking all non-racial variables into account, and I'm quoting, defendants charged with killing white victims were 4.3 times more likely to receive a death sentence than defendants charged with killing Black victims. The court in that case, McCleskey v. Kemp, did not contest the accuracy of those numbers. Rather, the 5-4 majority of the justices held that the disparity did not matter because there was no evidence, the court found, that it had been the result of a conscious, deliberate mechanism by law enforcement personnel or by prosecutors. This was and remains a jaw-dropping conclusion. After all, disparate impact can be accepted as proof of discrimination even in employment disputes without any demonstration that it was intentionally brought about. And there's more. In states like Texas, where the death penalty is most common, it is the high population counties where it is most frequently sought and most frequently obtained. And of course, in urban areas, minority populations are the highest. Of the 570 people executed in Texas since 1982, 238, 42%, were convicted of homicides in the three most populous counties: Harris, which is Houston, Dallas, and Bexar County, San Antonio, which during the relevant period represented together less than a third of the population of the state. Harris County has been a hotbed of death penalty prosecutions for at least the last 2 decades. But the problem is not limited to Texas. As Justice Stephen Breyer recently observed in a Supreme Court dissenting opinion, between 2004 and 2009, just 29 counties, fewer than 1% of counties in the country, accounted for approximately half of all death sentences opposed nationwide. And in 2012, just 59 counties, fewer than 2% of all of the counties in the country, accounted for all of the death sentences imposed nationwide. What explains this? Well, in many US states, local prosecutors and even local judges are popularly elected, sometimes even in party-affiliated elections. Law and order makes for a powerful political platform. Prosecutors who seek the death penalty and judges who impose it present themselves to the voters as defenders of law and order. And judges' willingness to send defendants to death row demonstrably improve their chances of keeping their jobs. And in a majority white jurisdiction, where racial animus may lie not very far beneath the surface, there is a clear, if perverse, incentive for death sentences to become political resume builders. Obviously, because more than half of the US states either do not have the death penalty on the books or do not impose it in practice, similar crimes are manifestly not treated equally across the country. All of these facts demonstrate beyond doubt that capital punishment in the United States is not applied equally. Whether a defendant and a crime are death penalty eligible depends, in addition to the facts and circumstances of the crime and the elements of proof available to the prosecution, on the race of the victim, on the race of the perpetrator, and on the place where the event occurred. The death penalty as applied in America thus clearly fails the first criterion of this analysis. It is not consistent with the aspirational words carved above the entrance to the United States Supreme Court building: equal justice under law. Now let's turn to whether the death penalty is applied predictably. Perhaps the facts and figures I have already presented demonstrate the answer to this question, but there is more to consider. Even within a state and within a county, is there any consistency in the outcomes of capital prosecutions? To answer these questions, we have to look a little more closely into the types of crimes that potentially qualify as capital murder and the types of considerations that might be presented as aggravators, enhancing susceptibility for execution, and as mitigators, suggesting the opposite. In no American jurisdiction is capital punishment available for simple first-degree murder, even if it's attended by the clearest premeditation and the greatest malice aforethought. Capital murder is murder plus. And in most places, that largely means first-degree murder in the course of committing another first-degree felony, almost always either robbery or rape. But of course, to obtain a conviction for any offense, the state must prove every element of the crime beyond a reasonable doubt and to the unanimous satisfaction of the jury. Often, therefore, a capital murder trial turns not on whether the defendant killed the victim brutally and viciously as charged, but whether the independent felony has also been proved. And on the jury's view of that separate crime, the life of the defendant often hangs in the balance. In a Texas case, for instance, there was little doubt that the defendant, a hitchhiker, killed the driver who picked him up. But the defendant was also accused of stealing the victim's wallet, which he adamantly denied. Notwithstanding the brutality of the crime, it could not be treated as a capital offense absent that other element. In effect, the theft of a few dollars became the fulcrum on which this case turned. And when the state failed to carry its burden of proof on the theft, the culprit was sentenced to life imprisonment for first-degree murder. That is not, of course, the only quirk in death penalty cases in which relatively insignificant factors determine the ultimate outcome. How does a jury interpret, for example, an instruction that age may be considered a mitigating factor? Let's say the defendant was 18 at the time of the crime. We were all 18 once. Are we to understand that 18-year-olds are so impressionable and so unformed that they are unable to resist impulses that might lead them to violent crime? But even if that is the case, then how can a death sentence ever be an individualized moral response to the act of an 18-year-old? And since this defendant teenager has been convicted of a violent crime, what does it mean for us, the jury, to take his age into account as mitigation? Once a defendant has been found guilty and sentenced to death, and his appeals from both have been exhausted, it is open to him to seek collateral review of both the conviction and the sentence, first in state and then in federal court. That means that he may seek a writ of habeas corpus, a control on the power of the government first codified by the British Parliament in 1679 during the reign of Charles II. The writ requires the state to justify, according to law, the detention of a person in its custody. And the writ is considered so fundamental to our American legal system that the Constitution itself provides that the privilege of the writ of habeas corpus may virtually never be suspended. Collateral review is not the equivalent of another appeal. A petitioner may not argue before the reviewing court that he is not in fact guilty, nor may he reformulate his defenses that the jury has already rejected. But he may put before the court his claim that his trial was corrupted by illegality, or that he was denied a constitutional right. It is at this stage where the prisoner may present his claim that, for example, he was not permitted to confront his accuser, or to compel the testimony of witnesses in his defense, or to be tried by a jury properly composed of his peers. And it is here that he may complain that he was not afforded effective assistance of his counsel, as is required by the Sixth Amendment. As might be expected, capital defendants are almost never able to afford counsel on their own. And capital representation is extraordinarily intensive in time and resources. So nearly every person at risk of a death sentence is represented at trial either by public defenders, a corps of lawyers notoriously overworked and underpaid, often simultaneously tasked with multiple full-time cases under impossible time pressures, or by attorneys who sign up to rosters maintained by local courts to take on defense cases as contractors to the state. Many public defenders and many lawyers who make themselves available for appointment are truly outstanding professionals. Many are motivated by a desire to make a difference in how justice is administered, as they would say, one defendant at a time. But some are not. Some are lawyers simply down on their luck with nowhere else to turn for a livelihood. Some are coming to the ends of their careers and are burned out. And no matter how dedicated they may be, they are at the mercy of the system that engaged them. In Alabama, for example, at the time our client was tried in 1996, his counsel was paid $20 per hour for investigation, interviewing his client and any witnesses, preparation, drafting and filing of motions and any other pretrial necessities, and $40 per hour for time in court, including presenting the defense at a capital trial. One should not be surprised, therefore, at the horrific pictures that emerge from the case law reviewing the performance of defense counsel in death penalty cases. There are reported instances of attorneys falling asleep or being drunk during proceedings. There are instances of newly admitted lawyers just weeks after having been called to the bar being handed capital cases to defend. So it is hardly surprising that appointed counsel may be very far from diligent in investigating the crimes of which their clients are accused, or the backgrounds of the clients themselves that may provide mitigation should they be convicted of capital murder. In our current case in Alabama, appointed counsel was experienced in criminal defense, but for some reason lost in history, he did not interview a single potential defense witness. He spent a total of half an hour on the phone with his client's seriously dysfunctional parents and learned nothing about his upbringing, or I should say, or his lack of upbringing. He did no investigation of the statutory aggravators on which the state indicated that it intended to rely to obtain a sentence of death. Tony Barksdale, our client, was convicted of capital murder, and the trial proceeded to the punishment phase. And there, defense counsel offered no opening statement, called no witnesses, introduced but a single document into evidence, and rested. In the case in mitigation of sentence, that is to say, the case in which he had to show the jury why his client should not be executed, counsel spoke a total of 21 words. The defense presentation lasted less than a minute, and the closing argument 5 minutes. Is that shocking? Well, I think so. But here is something more shocking. On collateral review, the local court signed an order denying habeas corpus, every word of which was written by the prosecution. That disposition of the case was upheld by the Alabama Court of Criminal Appeals as constitutionally adequate, and the state and US Supreme Courts both denied further review. After state remedies are exhausted, a prisoner has one final opportunity in federal court to obtain a writ of habeas corpus if it can be established that state proceedings involve constitutional violations. But a claim of ineffective assistance of counsel obviously cannot be entertained from every defendant who believes he was convicted unfairly. So how do courts decide? Suffice it to say that each and every element coming into play in such cases has been the subject of extensive and by no means always consistent judicial interpretation. And where the outcome, literally a matter of life and death, depends on such vagaries, the last adjective that could be ascribed to the system is predictable. And it gets even worse. President Bill Clinton, a vocal death penalty supporter, signed into law in 1996 a legislative monstrosity entitled the Anti-Terrorism and Effective Death Penalty Act. That statute was expressly intended to cut back sharply on the availability of federal relief for state death penalty convicts. And it has done just that, creating an impenetrable mass of linguistic thickets, providing a new list of ways in which federal constitutional claims can be foreclosed before they are even raised, depending upon whether certain words were or were not used in pleadings filed at the state level. In a few cases, including one as recently as last year, the Supreme Court has stepped in to prevent obvious injustice resulting from what may be essentially the collusion of prosecutors and state judges to see that death sentences are affirmed and carried out. But despite the factors, the constitutional factors that might cause an observer to expect a sympathetic ear on the High Court, the vast majority of habeas petitions are simply denied without opinion. Ours, incidentally, is currently pending. We expect to hear from the Supreme Court by the end of April. Next, is the death penalty applied proportionately? Punishment is proportionate to the crime, as logic and good order would dictate that it should be, if it reflects the fact finder's assessment of both the offense and the offender. Many who defend the death penalty as a law enforcement device declaim that there are some crimes so horrible and some criminals so evil that society needs no further justification for putting those people to death. Let's put aside the philosophical or theological question of whether there are certain human beings who can be said to be beyond redemption. Surely the New Testament provides no support for that view, but the role assigned to juries in deciding who lives and who dies asks them to engage in rank speculation. In Texas, for example, juries must opine on whether they believe that the defendant would commit another crime of violence if he were allowed to live. But how can anyone know that? And how can we be sure that even the 12 members of the same jury who are asked that question are understanding it in the same way? In this context, it would be remiss of me to ignore what many people feel is the most powerful argument against the death penalty, and that is that it is irreversible. Should an innocent defendant be executed, the state itself would have committed an indefensible homicide. However, like many capital defense lawyers, I'm drawn into this debate somewhat reluctantly. I do not know, and I submit that it cannot be known, how many innocent people have been executed in the United States. Surely there have been capital cases in which perfectly viable defenses were ignored or were excluded by prosecutors' misconduct or judges' clear errors. But even in those cases, how can we who were not on the jury be confident that the defendant was innocent, since that question was never asked in the courtroom? The word innocent is not a precise legal term. Juries never declare a defendant innocent. That is not what is at issue in a criminal trial. If by innocent, we mean that the defendant did not commit the offense but was 100 miles from the scene, then of course the prospect of killing him is simply barbaric. But what if he did pull the trigger? That is, he was responsible for the homicide, but the factors characterizing the crime as capital murder were absent. He was guilty of murder, but innocent of capital murder. And of course, this is a common occurrence, and it is troubling, even though the defendant was not innocent of crime. The bottom line is that the death penalty is simply not, as a matter of fact, reserved for the worst of the worst. Nor does the what about argument, the one that asks about the mass murderers, the Adolf Hitlers, the Osama bin Ladens, have any discernible relationship to reality. There is no guarantee to begin with that you and I will necessarily agree in our assessment of the instances of indisputable inhumanity. Some people believe that as creatures made in God's image, we cannot resign our membership in the human race with all the rights and privileges it brings, even if we wish to. But even if we do agree that a small number of notorious figures have by their actions relinquished the right to live, it is most illogical to base a criminal justice system on the premise that we might someday have to determine the sentence for a convicted architect of a Holocaust. It is far too easy for a jury not only to convict someone who admits to being a member of a gang, or someone who has never held a proper job, or who has lived his life at the margins of society, for the crime of capital murder, but then also to impute to him the additional motives required in aggravation of sentence. It is far too easy to ignore the evidence of a deprived, abusive, or abandoned upbringing that might be offered in mitigation. Whether an individual has, in some sense, sacrificed the right to live is a question that is at best ungoverned, subject to the prejudices and presuppositions to which we are all ourselves susceptible. Some in this audience may be old enough to remember the moment during the first debate in the 1988 presidential campaign when Michael Dukakis, the governor of Massachusetts and a death penalty opponent, was asked by the reporter Bernard King whether he would support the death penalty should his wife Kitty be raped and murdered. His answer was this, and I quote, "No, I don't, Bernard. I've opposed the death penalty during all of my life. I don't see any evidence that it's a deterrent, and I think there are better and more effective ways to deal with violent crime." That bloodless answer may well have sealed the fate of his long shot chances for the presidency, although the race baiting by the George H.W. Bush campaign that followed surely took its own toll. Of course, every time someone is raped and murdered, that person had someone, perhaps many someones, who felt for her as Governor Dukakis obviously felt for his wife. The death penalty cannot be allowed or defended if the victim is my daughter, but not if she's yours. The answer to King's question, the proper answer, is that we have a legal order in our society precisely to prevent personal inclinations to vengeance from being carried out. To allow Michael Dukakis's or your or my feelings to determine how society deals with those who have offended against its rules is to invite chaos. So would Governor Dukakis would he have liked to kill the person who mutilated someone he loved? Probably. But that is not relevant to the question whether we should tolerate the use of the death penalty as a society. No, there is no evidence for the view that the death penalty in America is reserved for the worst of the worst. Finally, is the death penalty consistent with the laws and practices of other countries? There is, of course, a vibrant debate among lawyers, academics, and judges about the proper role, if any, of international and foreign law in understanding our Constitution. Justice Breyer has for years been the most prominent champion of a flexible approach to that question, while Justices Thomas and Alito are, and the late Justice Scalia was, the leading opponents. But as Justice Kennedy, no liberal himself, made clear, when the drafters of the Constitution used such phrases as cruel and unusual punishment, they clearly anticipated that the interpretations of their words would change over time. Obviously, What we deem cruel in 2021 is far different from what the white Christian male landowners who drafted the Bill of Rights, many of whom purported to own other human beings as property, thought was cruel in 1791. The United States stands today nearly alone among the nations of the developed world in its use of capital punishment. The Organization for Economic Cooperation and Development, the OECD, has 36 members, those states most advanced according to economic and social metrics. Of those 36, precisely 2, the United States and Japan, still provide for judicial execution as punishment for crimes. It has been abolished everywhere else. This element of the much vaunted American exceptionalism is not seen as a detail or an endearing quirk among even our closest allies. To the contrary, membership in the Council of Europe requires repudiation of the death penalty, and its rejection remains an important focus of concern around the world. The fact that the United States is an outlier on this issue, of course, does not mean that we are wrong, but it does mean that the spirit of the times, as seen through the lens of Western democratic states, no longer countenances the practice. Yes, the International Covenant on Civil and Political Rights, in force since 1976, does not require, but it urges abolition, and human rights instruments have routinely promoted that goal. So, to the question whether our adherence to the practice is consistent with the laws and principles of our peers in the international community, the answer, once again, is most certainly no. So I hope I have succeeded in demonstrating in this presentation that the death penalty as applied in the United States today cannot be reconciled with the fundamental tenets of our democracy. It is not applied equitably, predictably, or proportionally, and it is simply out of sync with the values inspiring virtually every other country on earth of our stage of economic and social development. Many members of the audience still attentive at this point will perhaps have noticed 2 empirical arguments to which I have not even alluded. I have not argued that capital punishment is demonstrably not a deterrent to crime, or that it is an enormous waste of economic resources. I think that both of those statements are true, but I also think that they do not demonstrate, they do not justify the application of the death penalty as practiced in the United States today. Both of those are firmly established in the relevant academic literature, as well as by hard and confirmed evidence. With that, let me thank the organizers of this program, Hopkins at Home, once again for inviting me to deliver this talk. I hope I've provoked some critical thinking. Perhaps I've challenged some assumptions that listeners previously entertained. I do hope I'll now be able to hear, and I'll try to answer your questions. And of course, I'm grateful to all of you in virtual attendance for your interest and attention. Thank you. Now, let me look at the questions that I see in the chat box, I hope. And I'm asked, I use the expression, the values of the community of nations. And I'm asked, how do you define that term? Some Asian countries, like China, tend to execute drug sellers for historical reasons. Many other countries would not. Well, I would suggest this. China is a party to the International Covenant on Civil and Political Rights. So is the United States. The entire world community, or virtually the entire world community, has committed to certain principles of respect for human rights. I would argue that the use of capital punishment for non-homicide crimes is itself a violation of human rights and should be challenged as such. But certainly, whether that argument is correct or not correct, it is certainly far from the standards to which the United States, as a Western democracy, would wish to hold itself. Next question is, at what point in US history do you think the justice system lost its way relating to capital punishment? Well, I think the answer to that is at the very early days. I think a better question might have been, no disrespect intended, obviously, at what point in US history has the justice system begun to find its way? Because there was judicial execution back in the days before and surrounding independence and the adoption of the Constitution and the adoption of the Bill of Rights, and it was disproportionately imposed on people of color. It was disproportionately imposed on people who had been enslaved and therefore whose very humanity was doubted. So it is only recently, I think, only in the latter part of the 20th and the beginning of the 21st centuries, in which we have begun to catch up and begun to ask ourselves whether cruel and unusual punishment does not require another look. The United States believed, and it was on the books in many states until 2005, that it was consistent with the constitutional prohibition of cruel and unusual punishment to execute a person who was 16 years of age at the time that he or she committed a violent crime. The court said in 2005, no, that is not only cruel and unusual punishment in itself, but it also constitutes a denial of constitutional values of the greatest importance, the due process of law. That is, that everyone is entitled to certain kinds of equal treatment in the judicial process. Unfortunately, we have not yet lived to see the day in which that goal has been realized in this country. But I think we cannot doubt that progress is made, and not only the declining number of states that execute, the declining number of executions, and most importantly, the declining number of new death penalties, new death sentences being issued, does hold out some prospect for hope. How has the military recently viewed the death penalty is a question in the chat. And the answer is the military retains the death penalty for crimes such as desertion in time of war, but I don't believe the military has actually carried out an execution of a prisoner since the 1940s. And if I'm wrong about that, I apologize. I'm not wrong by much. So the military retains the death penalty on the books, as does the federal government, which leads into the next question. Can you expand on why the Trump administration chose to execute 13 prisoners? 13 prisoners were executed, as I said, over a period of 6 months. In the previous 7 decades, the United States government had not executed that many people. Why? Why suddenly? And I submit to you that the answer is, and I don't mean this to suggest cynicism, the answer is clear. It was an electoral issue, that the execution of prisoners, many of whom committed, beyond a reasonable doubt, horrific crimes, their execution could be seen as the Trump administration defending, embracing the principles of law and order. The principles that are invoked so frequently and understood so rarely in the political space. The arguments that were given were the ones that you would expect to hear. The arguments that we heard from the administration was not, we're doing this because it's politically popular. They said, we need to do this to bring justice to the victims. The victims, of course, are dead. So bringing justice to them is perhaps something that we can discuss in concept, but something whose actual application is subject to at least a certain degree of confusion. And indeed, bringing justice can all too frequently be code words for exerting vengeance, revenge, retaliation. And indeed, I would submit to you that although this is now a theological and no longer a practical discussion, the notion of revenge or retaliation really, in my mind, is the only viable defense for the death penalty. The only viable defense in principle is that there are perhaps some crimes or some people so beyond the pale, so beyond what is acceptable, that the state may not permit such a person to live. But to get there, one has to accept a certain vision of what the state is. One has to accept a certain understanding of what it means to give up the rights of humanity. Those are questions about which reasonable people disagree, indeed disagree in some cases rather dramatically. And given the notion that this country is founded, among many other principles, on the separation of church and state, the prohibition against establishment of religion or the interference of the free exercise thereof, it seems odd at least to base a premise of the criminal law on a theological principle with which many Americans may disagree. And yet, again, if that is the basis of the defense, I would argue it may make philosophical sense, but it doesn't make very much practical sense. And it doesn't fit into the Constitution. I'm asked, what would you say to those who reject abortion but support capital punishment? And of course, if you accept the retaliatory explanation that I just gave, the lex talionis, using the biblical term that I just gave, then presumably the argument would be that aborted fetuses, if one believes that they are human lives, are innocent. They have not, in any sense, drawn upon themselves the termination of their existence, while men and women on death row have. They had a choice, and they made a choice. And that choice brought with it a certain level of culpability. And that culpability, therefore, invited the exercise, again, of retaliation if one accepts that premise. So I'm not convinced that there is an analytical inconsistency between support for the death penalty and opposition to abortion. I think there is a place to draw that line. But again, I think it's a theological place and not a political one, and certainly not a legal one. And then what I believe is the final question is this: what institutional components would be key to, that would need change if we were to attempt a systemic resolution of the factors that led to the inappropriateness, the inconsistencies, the anomalies that I have been talking about for the last hour? I think this could come from a number of places. Obviously, there is always the possibility that a Supreme Court will conclude that in the 21st century, execution by lethal injection or by nitrogen suffocation or by firing squad or by electric chair are cruel and unusual according to the standards of the day. That's a possibility. It's also possible that the political branches of our government will someday decide, for whatever reason, that the death penalty is no longer tolerable. And we're seeing, I think, increasing political movement in that direction. We just saw it in the Commonwealth of Virginia, again, the first of the former Confederate states to abolish the death penalty. And obviously the former states of the Confederacy are the ones that have been most active in using judicial execution over the last several decades. So at the state level, there may well be, if not abolition, at least restriction. For example, I described to you the procedure in Alabama that permits judges to override recommendations by juries against the death penalty. That's obviously abhorrent. I don't see any reason in the world why the Supreme Court has not already struck it down. We are asking in our case to have them do it. Probably as a realistic matter, probably not inclined to, but there's hope. So the answer may come from the judicial chipping away at the building blocks of the death penalty, or the legislative repeal or alteration of the building blocks, the determination that the populations are simply unwilling to incur the risk of executing innocent people, the economic costs, or any of the, what I would submit are sounder arguments that I laid out in front of you today. All of those are possibilities, and all of those at the end of the day, I suppose, are up to us. If there's going to be political movement behind abolition, then it has to come from somewhere. And the only place it could come from is the citizenry. And perhaps the organizations of citizens that need to be involved here are not only the usual civic groups, but churches. Churches and synagogues and mosques around the country, temples, ought to be engaged in this issue, because they ought to find that at the fundaments of their religious beliefs, there does not exist the opportunity for the state, rightfully, to take the lives of its citizens. So I think that concludes the time that we have available. I'm again grateful to the organizers of Hopkins at Home for inviting me to make this presentation. Grateful to all of you who are in attendance, not only those who ask questions. And I hope that if you are interested in continuing this discussion, reach out through Hopkins at Home to me. There are some written materials that perhaps you might like to see that would further develop the arguments that I have been presenting to you. And of course, most importantly, follow the news. There are developments daily relating to this subject. Just today's paper reports that the federal government is appealing to the Supreme Court the reversal of the death penalty for the Boston Marathon bomber, and putting perhaps President Biden in a difficult place, since he is an opponent of the death penalty and said it won't be carried out on his watch. And yet his government is now asking the Supreme Court to impose it on the surviving member of the two brothers who were responsible for that horror in Boston. So it's a current issue. It's in the news every day. Pay attention. And I suppose that's probably the envoi. Pay attention to this issue as it develops. It affects all of us. Thanks for attending.